Welcome everyone to this new episode of the Privacy Rules PrivacyEspresso series, a series where we delve into the latest news on privacy, data protection, and in general with any matter related to technology, together with the expert of the Privacy Rules Alliance and sometimes with guest speakers from out of it. Today with me I have Pieter Gryffroy from the law firm Timelex, based in Belgium and member of the Privacy Rules Alliance for it. So thanks a lot for being with us today, Pieter, first of all.
Thank you, Alessandro, for having me.
Okay, Pieter, the reason why I'm very pleased to have you with us is that the topic of the day is one of the big one of the moment that is related to the AI Act. But the reason I would like our listeners to know why you are here is that you also made a very relevant together with some of your colleagues at Timelex, analytical report that is available on the EU Open Data Portal related to this topic, because was something about role of artificial intelligence in processing and generating new data. And this makes you a perfect expert to speak about the topic and the AI Act. Can you just give us a bit of updates on what this report is about?
Yes, sure thing, Alessandro. So the publication that we did is indeed from the angle of open data, and specifically how may you use AI to process data, to create new data. So it's a bit of the topic of synthetic data as well, using AI to create new data sets, which may or may not be personal data. That's a bit of a hot topic as well. So but that's kind of the angle that we wrote from. But nonetheless, I think the content is quite relevant for also other applications and other use cases using AI. So I would recommend people to have a look at it also if you're not dealing necessarily with open data sets from the EU Open Data Portal. And it covers just three big topics, so to say, in AI compliance. The first being copyright. So from two angles there. The first angle is, okay, what can you do with existing data, specifically straight from the internet? So the text and data mining exception. When can copyright actually allow for you to use freely available data? But we also deal with the topic of, okay, can AI actually have copyright? Can AI be an author? What about prompt engineering? When is a prompt original enough that the contents that the AI creates based on your prompts may be copyright protected? So that's section pillar 1 of the report. The second one is about the fundamental rights implications. So that's definitely privacy and data protection, but also more broadly, that depends, I think, on the use case, the domain of application. You may have specific other fundamental rights that feature into the consideration. So if you're dealing with law enforcement, then you're dealing with right to fair trial, good administration, presumption of innocence, all these type of things. Whereas if you're dealing with in other contexts, there's potentially different rights that apply. For example, something in the field of journalism may trigger freedom of expression concerns. So these are the things that we have to take into account. That's pillar 2, the fundamental rights angle, which is also quite prominently present in the AI Act. And then pillar 3 is the actual AI Act. So this was written just before the AI Act was published, 12th of July. We finished this end of June. So we were unlucky in that sense, I guess. But the text, of course, didn't change much anymore. So the publication is still quite relevant. It's completely relevant. I mean, there's nothing material changed in that time. But that covers the AI Act specifically from the angle of open data, but also more broadly. So it deals with, okay, what are the basic principles of the AI Act? How does it apply? When does it apply? What to take into account specifically from a provider angle if you're making an AI system to do this open data application or something else. Again, it's broadly written, or also from the deployer angle. So what do you need to take into account if you're using a system that already exists? So I guess that's quite relevant. Look at this publication today.
It is indeed, and that's why I'm very pleased. And it sounds like the report and the work you've been doing has a very strong practical approach. So I would really invite everyone to have a look at it. I will be the first one interested on that. And taking the ball from what you were just saying at the end of your quick introduction to this topic, we know that with 12th July, we had the AI Act published, and you have this very practical knowledge of the topic. So I would like also to start making some more practical questions to you. The first of which is for companies that needs to deal with AI and the AI Act specifically. What do you think they should be focusing on based on the text that we have now?
That's a very fair question, Alessandro. A very difficult one as well. So I'll try to keep maybe a high level first. So I think the main sort of motto here would be position yourself. So look at what does an AI system entail under the AI Act? When does it apply? So the AI system definition is really broad, catches many things. But the AI Act has a risk-based approach, as we call it. So it basically means it mostly regulates high-risk use cases, and that falls in two categories. already regulated products, for example, medical devices, machines, or safety components of such products. So AI that is used as a safety component, for example, of a medical device. And then there's the Annex 3 with the regulated specific higher risk use cases. And that really depends on certain domains and risks of application. So, for example, in law enforcement, this is considered a lot of uses for law enforcement, specifically noted of, and of course, only those risks are really high risk. But based on certain domains of application, as we call it. So, for example, biometrics is usually a high-risk application. Critical infrastructure is one of the examples. So there's many examples that are really indicated as high risk, and they are strongly regulated. But I think it's important for companies to realize that that's the main kind of regulation, and there's some specific regulation for general purpose AI. There's some specific transparency rules for direct interactions between AI and people. And then there's a couple of forbidden use cases. Again, the forbidden use cases are very clearly defined. So if it doesn't match that exact description, it is not forbidden. And then usually it's a high risk application. If it doesn't really match the high risk application, then it's usually just allowed. So it's important to really understand which potential projects or applications that you're thinking of are actually in those categories that there's actually rules under the AI Act applying to it. And then the next step, I think, high level, is to determine what is my role. Am I a provider making a new application? Am I a deployer using an application? There's other roles as well, importer, but these are not as common. So the most common ones, I think, would be to build an AI system for a specific purpose based on likely something that's already there or from scratch. Then you're a provider, then you have very strict regulations applying. But again, only mostly for those high risk applications. So if you're doing it for something else, you're not really covered. You could also be a deployer quite easily. So the deployer threshold, so to say, is very low. So as long as you use it in a professional setting, you would be a deployer. But again, it's only for high-risk applications that the most stringent obligations apply. So it's important to understand your role, but it's also important to understand whether it actually relates to one of the more regulated categories or not. If you are a provider, then you have quite a lot more obligations. You have your quality management system, risk management system, data management, conformity assessment, lots of obligations. So it's important to realize that you have that role if you do, because it attaches quite a lot of obligations. I think usually that will be quite proactive that you're thinking about building an AI system. I think it's more likely that somebody doesn't realize they're a deployer then they will not realize that they're a provider. That is because deployer obligations will also attach to high-risk systems that you may not always be aware that these are there. What I mean by that is that in existing systems in particular, you may already have AI applications. There's a transition period for that, but there's also a note to be made that as soon as there's significant updates or changes, the AI Act will apply. So I think there's a high likelihood that people don't necessarily realize that the software suite, the solution they're using, actually has regulated AI in it. And then it's quite important to make sure that you understand that deployer obligations will attach. So generally, I think the best thing that companies should do is try and do kind of a mapping exercise and see, okay, where does the AI Act apply to us? What projects do we have? What potential solutions or software do we use where there's AI? And when may it or may it not apply? It's important, I think, to position yourself, try to get an understanding what potential AI tools and projects do you have within the organization, and does the AI Act actually apply to them, yes or no? Even outside of that, I think AI risk assessment is going to be a thing even when the AI Act does not apply, because it's additional risk. You've got your GDPR obligations, you have maybe other legislation that applies. You can think about NIS, you can think about other things. The risk assessment is generally the big thing in EU legislation now. So I think even outside of the specific scope of the AI Act, even if it's not a high-risk system, you might still want to look at AI risk assessment just as good practice.
That was perfect, and it's related to the technicalities of the topic, I believe, but I definitely got the point that even if AI Act is pretty narrow in identifying who falls within it, still there are also many other regulation and many parts that thanks to which the AI Act can be of interest to companies, meaning that following it can help you complying also with other regulations. So definitely worthwhile to have a check to it, and needs to be studied well in order to understand if you're falling or not within it. An interesting thing I've been hearing a lot is you mentioning about deployers and their roles and their obligations, let's say. In this regard, can you give us a better understanding about what deployers have to think about, which are their duties and what they have to do?
like I said, the providers have the more stringent obligations, but I think sometimes it is a little bit underestimated that deployers do have their own obligations, again, specifically for high-risk systems. So if it's not high risk, then it's not necessarily regulated unless you have the specific transparency rules. And there's also the element of using general purpose AI. We'll come to that at the end. There's a risk hidden there for deployers. So mostly for deployers of high-risk systems, and it's important that they understand that you have to take what we call TOMS, technical and organizational measures, to make sure that you can actually use the system as it's intended. And this does require some training and personnel that actually has appropriate knowledge to use the system. Of course, the better the provider does their job providing clear instructions, the easier that may get. But I think deployers should not underestimate that they also need to invest in preparation, training, and having sufficient knowledge to make sure that they understand what the system can and cannot do, and that they understand how to implement it specifically in their specific use case. Because there's always going to be a little bit of a disconnect of a provider that really understands their system really well, tries to explain it. The more knowledge you have, the more you can ask a provider to give more information, the more you can have an open debate and clearly understand what the system does and how it works, the better the deployer will be able to use it. Because deployers also, for example, have to monitor the operation of the system. They have to notify risks, issues. When they are in charge of their own data, they need to make sure that their input data is representative, is relevant, so that they don't introduce additional bias, they don't create situations that are discriminatory. They need to organize effective human oversight. I mean, these things, keep in mind, are legal obligations. You have to legally be able to show that you have effective oversight in place. So I think this should not be underestimated, that especially for organizations that are public authorities, law enforcement authorities, or that have a lot of potential reputational damage if they don't do something right, that these are not just best practices, these are standards that must be reached. So in that sense, you need to start thinking of AI policies internally, like what can be done, who can use AI, for what purposes, what are the safeguards to put in place. You need to think about preparedness. You need to think about training. You need to maybe think about knowledge on the management level as well of AI systems, just like NIS says, well, you need to understand what information security risks there are. Maybe also the C-level needs to understand to an extent what the AI policies are and how the organization deals with that. There's already ISO standards on this actually, so there's already things being developed, and that will only continue as we go on. I'll come back to the thing I said at the beginning of this answer, just one more minute, is that if you've got deployers that are using a system, it is as they mature and as they become more confident with the system, they may want to say, okay, I want to build something more specific. So the system works well, but I would like, specifically when it's a general purpose AI, maybe to build something on top, like to substantially modify it. But if you do so in a way that it becomes high risk, or that you modify a high risk system in a way that it remains high risk, you become a provider. And that's a tricky bit. Especially, I think, for the general purpose AI, if you modify it in a way that it becomes high risk, you become a provider, and that triggers a host of new obligations. That is something to pay attention to, as well as, I think, an even more tricky one is when you put your name or trademark on a high risk system. So when you say, okay, we like the system and we're going to, for example, as an association, try and push this to our membership, and we'll market a specific version of this as our thing. Contractually, this may be okay. You may have the rights to that, but that can really trigger that provider role, provider hat under the AI Act, for which you may not necessarily have all the information. And then, okay, the AI Act clarifies that the original provider has to help you with that, but you do take on quite a lot more responsibility all of a sudden. So these are some things to take into account when you're a deployer as well. Not only use it well, but if you want to go that next step, so to say, make an additional check of, does that imply certain obligations that perhaps we don't want to trigger?
That's, Pieter, is impressive. I mean, listening to you and see how much you need to know about this topic, also to be aware of the intricacies that are behind it, the risks that sometimes are hidden. And this is probably the reason why, companies should be always, speaking with experts that really know the matter very well as you do, in order to make sure that they are doing things in the best possible way. Thanks a lot for, making us aware of all of these in just a few minutes. That was incredible. It's been a pleasure having you with us. Next week, we will have your colleagues to speak about this topic on fundamental rights together with us. So I very much look forward to meet our audience there together with us. And I thank them for listening to us. Pieter, thank you again for being with us today. It was a pleasure.
My pleasure, Alessandro. Thank you for having me.